Good evening, everybody. If you would, please rise for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Could I have a roll call, please?
Mr. Cole?
Yes.
Mr. Huff?
Yes.
Mr. Brucker?
Yes.
Welcome, everybody, to special meeting, Morgan Township. Trustees, August 24th, 2023 at 7:01. I do have a statement I'd like to read. I'd like to address the audience here and those listening online concerning the purpose of this special meeting. These types of meetings have specific and narrow focuses to address only those issues that have been brought before this board. This body has presented and will hear a resident's concern about zoning compliance. Often there are court rulings issued to help resolve these infractions, and other times a court ruling may be required to resolve infractions. There are also times when property owners find solutions that arise between themselves. The Morgan Township Zoning Office operates by a defined set of zoning rules and regulations. They are never changed unilaterally, meaning by one person. And there exists a zoning board, a zoning administrator, and a board of township trustees to ensure it works fairly, correctly as designed, and is transparent. This protects everyone. I just wanted to bring that out, and I know there's a lot of concern here tonight about this topic, and I hope that kind of gets us off on the right foot. So with that, let me turn it over to Dale for kind of an introduction concerning what this is all going to be about tonight, and he will prepare us for the topics that we're going to be discussing and hearing about. Go ahead, Dale.
All right. We will be discussing the property at 6875 Hamilton Scipio Road concerning what one resident feels has been zoning violations by the builder, the owner of the property at 6875 Hamilton Scipio Road. She is here tonight to show those. They range from one, the side yard setbacks not being met, to also several other issues that really do not belong to zoning in terms of a fence in that respect. But however, in 2015, the resident at 6870 purchased the land from the Miss Susan Schulteis here, who's sitting in front. He purchased the land and proceeded to go through the steps needed to build a home on his property that he had purchased. In the process of doing that, he also purchased an extra piece of land in order to acquire and maintain the proper setbacks for the property. So in 2015, that was in August. If I get that out, it was actually, he was approved for a certificate August the 11th, 2015, not by me as the zoning administrator, by the former zoning administrator, Mr. Ed Teets. A stick frame house with a single basement with setbacks for the backyard of 62 feet, for the left side width of 31 feet, for the right side width of 115 feet, and the building height to be 20 feet. Those were approved by Mr. Teets, and for those of you who have a copy of this, if you would look at one of the pages, there is an addendum to it where it says, on my copy it says, see the back of the front page, you have this. This zoning certificate is valid only if 0.368 acre parcel is added to the back of the 2.67 area parcel number 4. that was done as shown in this particular plat of the land, which was presented to Mr. Teets at that time, okay? If you will notice very deeply in there, for those of you who have this in front of you, notice the terrain lines and everything else. It was my understanding that Ms. Schulteis asked, and I'm going to mention the owner's name, Mr. Gaines, to build his house here in this area right through here, which is the thing. Looking at this, and I do not have it where I could put it on the screen and everything else, I can only assume that Ed, and that's assuming, that Ed looked at this and said, okay, there are issues here that prevented Mr. Gaines from actually being able to build the house where Ms. Schulteis requested or asked him to build in that respect. One, right down the middle of this, or through this, there is a swell that goes from his driveway down toward the pond of the other property. Two, he was not forced, but he was asked by the Board of Health to place all of his septic lines to the front of to this property, just above the swell. He also has his propane gas coming up the side there and is in the ground over on this side of the house. If I'm getting this right, please stop. Getting this wrong, please stop me, Mr. Gaines, okay? So therefore, Mr. Gaines looked, where could I place it? And as most of you might be able to see, or at least those of you who have it, he placed it so that the house was on the left side was 25 feet setback, which was the minimum requirement at that time for the property. He's at 61 feet with the new property, because you can see that the 0.3 acres were, were added, and so he has 62 feet going back that way. And that is true today, and everything else. And then the right side was not an issue in terms of all of this, okay? So in September the 8th of 2016, Mr. Gaines came in and asked for a zoning certificate, not a permit, because we don't give permits, we give certificates. A distinction I wanted noted. He came in to ask for a certificate extending his deck to the master bedroom walkout on his new construction. It was approved, excuse me, don't mean to be losing my voice. It was approved by Mr. Teets, and I have no other information other than the rear yard was going to be 62, the left side was going to be 25, which reduced it from the house, okay? The house was at 31, so it was taking 6 feet of that away. The right side was 115, and the building height was going to be 12 feet high, meaning the deck was going to be 12 feet off the ground. At that point, I'm out of knowledge in terms of what happened, okay? I can't say, other than I've gone out, I've seen the deck, I've measured the deck from the support post, which is where it's supposed to be, because he did extend it out over those posts. And I've found that through pictures and other things that is at 25 feet with where the support posts are, which is what is recognized as where the structure begins.
What is the allowed overhang?
The allowed overhang is 3 feet.
And what is he?
That, I'm not sure. It's 2, 6, or close to 3.
So it doesn't exceed 3.
It doesn't exceed 3.
Okay.
That's where
So-
we're at. That's what we're here to discuss, I think, more
So,
than
yeah, I think-
anything else, according to what I read in
Okay.
Ms. Schulteis' letter.
Okay. This is not a court of law, and we can't adjudicate, or we can't make a ruling This is to hear citizens' concerns and to try to make it right with the citizens, and I think everybody understands that. So what I'd like to do, Susan, is just go ahead and let you address, our last meeting, Mr. Gaines was here, Chris was here, and he spoke and talked a little bit about his concerns and scenario, and you had come and asked an opportunity to do the same. So with that, if you'd like to go ahead and address the overhang issue, I think that was the first thing that was on your agenda, correct?
Can you hear me okay?
Yes, could you introduce yourself, give your name?
My name is Susan Schulteis. We live on Weaver Road, Okean, Ohio. First of all, we did not ask Chris Gaines to put his house anywhere. He chose to put it where he did. The drawing he had was the original 2 acres that we had Mike Hall, a professional developer, identify the best location for that home, so just to correct the records. It is my understanding, when we first came and asked about the setbacks, you have a copy of the letter, and I'll bring it again. I had contacted Ed Teets and said, this is what we have. We have a deck sticking out, and I even provided a picture, like picture 1, when I came to the meeting and said, we would like it cut off. Ed Teets had informed us at that time, and it's on your tapes. Let me pull my dates out. That, yes, there's no exceptions in the 25-foot setbacks except for roofs. I think that's in your email there that he got. So, as Teets also informed me that Chris Gaines knows what the setbacks are, and he will cut it off. That's what we were left with in his email, and that's what we assumed was going to happen. Then we get the email, again, that he's referencing from Ed Teets. And my comments are on that email, because it does not say that we're allowing a 3-5-foot overhang. It does not say any of that. It just says it has our approval from this office. And my question is it legal? Because according to what I was told earlier, and according to what's in this book, it is not legal. Anything that goes in that 25-foot setback is not legal. That's what this book says. Ed Teets stood up in the meeting. Let me get my notes because I got it written down. I got it written down verbatim. At the October the 11th, 2016 meeting, we had September 7th, 27, we went to the meeting and provided information and asked to please enforce the 25-foot setback. Ed Teets said he allows setbacks sometimes, and it would only be fair since his predecessor did not enforce zoning all the time. So at that time, I asked fair for who. I also asked, I said, the deck is clearly a zoning violation. Ed Teets said, Chris Gaines knows what the setbacks are, and he'll cut them off. This is in your recording on your meetings. The trustees asked him to measure it, check it out, and get back for the next meeting. Asked Ed Teets to. The next meeting that we came to on October the 11th, attending Ed Teets, I asked and attended, what has changed in the zoning code from the time that you told me it was going to be cut off till now? What has changed? Because there's been a reversal in this decision, and I can't find it in here. And that's when he stated he did not always enforce them. He allows for some deviations, and I requested a list of all deviations from the criteria in here not to enforce the zoning setbacks, and I was informed deviations are not recorded. Well, that is in direct violation of your zoning code. I never received any information on deviations, and I will be putting it in writing, because I want to know why some exceptions are made for some people and some are not, and it's not in this book to allow this.
If we look at Mr. Gaines' deck, Mr. Gaines' deck meets the 25-foot setback. Is that correct, Dale? And what is the you stated he has an overhang of 3 feet?
Yes.
3 feet, okay.
If you look
Yes.
at, if you look at picture 13 of the packet you guys got, I have to ask you, does that look like, and I was told it was gonna allow 2 feet. Ed Teets said back in 2016, he was gonna allow 2 feet. Does that deck on picture 13 look like it is 2 feet?
Well, Dale was just saying 3 feet.
That's still not allowed here, I'm sorry. He's
Okay.
referencing.
Well, I just want to
What-
get the
Ms.
number
Schultes,
right.
May I
No.
ask, you were specifically looking at that book and telling me that it's not allowed here. What sections is saying it is not allowed? Give me numbers, please.
Okay.
Because I can't stop it.
19.1, under Article 19, under exceptions and modifications, the requirement and regulations specified herein above the resolution shall be subject to the follow exception, modifications, and interpretations. Existing lots of record in any district where a dwelling is permitted and one-family detached dwelling may be erected on any lots of record at the effective date of this resolution, irresponsible, and this is when Ed Teets told me this is where this is applied, irresponsible of the area with or the owner of which did not own any adjoining property provided. And it goes into, he said, the only time we make exceptions and modifications is what I was told on narrow lots that were already in place when zoning came in place. Mr. Gaines does not have a narrow lot. It is a new build. I've
Why does this picture, Dale, when I'm looking at this, and you're saying there's a 3 feet overhang on the deck
Yes, sir.
outside of the piling,
Yep,
does that match what you see when you've measured that?
yeah,
Okay, is that 3 feet?
yes,
Okay,
yes.
That picture looks like 3 feet, it's at least 4 feet. I can go to the auditor's page and measure it, and the measurement of the auditor's page from my fence line to the deck stick out is 15.8 feet from the auditor bird's eye view straight down.
okay. Then we've got somebody's ruler is off by a factor.
7 feet.
So I can only go by your measurements, Dale. If you
At
say
this
that's
point in
3
time,
feet, and
The
then
extension out over that from where the other parts of the deck are is 3
Okay.
feet.
let
The
me
deck is 12 feet, so that would be the 15 feet.
ask the one who should know, Mr. Gaines, is your deck 3
Could you come up to the podium, please, and
Is your-
introduce yourself?
Is your deck, let me show you this picture too. That'll help.
I want it measured, I'm sorry.
Okay, just preliminary, just
Thank you.
all comments in there.
Thank you.
Go back up there and introduce yourself, if you would, please. Does that represent your deck right now?
Yeah, this is my deck. Chris Gaines, 6875 Hamilton Scipio Road,
Okay.
here for the 3rd time over an issue that's been approved. Yes, this is my deck, and it's roughly at 3 feet overhang
Okay,
with the steps that are now
but
on
we're just
there.
talking about the overhang right now.
Right.
Is there any reason why we're seeing 3 feet at one point and then hearing a 10-foot overhang? Is there any way to explain the disconnect right there?
I mean, if you're measuring from a website, you could be off a millisecond, and it could give you a foot. So I don't know. I'm not familiar with the website. That I don't go around and measure people's yards or anything. So I don't know.
Okay.
Dale's been out.
I just want to
Ed's
get your,
been out. Everything's been approved.
I just
So-
want to get your input on that. Okay, thank you.
Dale, do you have those pictures that you sent us? I'm trying to
I
find
don't
them on
have
my
a
phone.
numbered, but I do have one.
One that shows your tape from the fence over
For the deck.
for the
itself.
deck, yes.
Can I have a comment here?
Sure.
he says it has been approved. It may have been, but that doesn't make it legal. I just want to make that point. It may have been approved, but that does not make it a legal deck. I'm sorry.
Well, complying, right now, we're only complying with the zoning,
Right.
the zoning
That's what I'm
guidelines.
saying. Here, yeah.
Yeah. So if it's 25 foot on that piling, on that concrete piling, and we got a 3-foot overhang, at this point, I don't know where to go from here, because it's,
It's more than 3, I'm sorry. Yeah.
It's more than 3.
okay.
I mean, you can look at that concrete piling and just judge the width and look out there, you're looking like 4
That's
feet.
my measurement of that, but not the deck.
Did you get
Not
that,
the
did you get that overhang, a picture of that
No,
overhang?
I did not.
Okay.
But I did measure it.
Then we got
at
some
3
work to
feet.
do.
So you're allowed
If-
to measure according to your own book.
Yeah,
You're allowed to go in there and measure.
yeah. There's supposed to be also, when you
Well,
apply for your permit, there's supposed to be an inspection.
In the spirit of cooperation, I want to make sure everybody is comfortable with how we're resolving this,
He's
okay?
already denied them access.
Yeah, he's already
Mr.
denied you,
Gaines has already
denied
that.
access.
I think,
He has since reversed that, though. Thank you.
Thanks for that information and the introduction, Dale.
Yeah. So much for keeping everybody above board. And
okay.
He did say he did since then go out and remeasure the deck.
Okay. Okay, so let us address, we will address that issue. We've
That-
heard your concern in both parties now, so I know you have another issue that you want to talk about
do.
too.
I do. That would be, not that one, we've already discussed that. Let me find it. The letter that was supposedly sent to us from the township zoning, one of the things that may be questioned is why are we just now bringing this up? The certified letter that was supposed to be sent to us that we never received from 2016, it's in the stack here. Here it is. This is dated January 30th of 2018. And then this goes to the process that's being followed or not. I first received this letter from Daryl on Saturday. This letter references what we've just discussed here for exceptions and talking about your exceptions, and we move my page here. Let me go back here. Modifications. Mr. Dale Marshall references exceptions and modifications. Up till now, I've never heard that being a reference to any new construction. And that's what's very disturbing is this letter dated January 30th of 2018. I just got it from Daryl Huff on Saturday. I bumped into him at the post office because my neighbor knew all about it being delivered into my post office box, but I'd never seen it. We'd never seen this letter.
You should have his signature.
And I don't have any certified mail because according to the zoning laws, it says that should have been mailed by certified mail. But nobody can provide any documentation of the certification of this letter that I never received. And if I had received it, I would have been here like white on rice the next day to say, what is going on? This is not a valid reference to exceptions and modifications on a new construction. So that's where I have a real problem with how this has been playing out. This has not been playing out fair, I don't feel. There was one other thing I was going to show you that I just buried here. For exceptions and modifications, I brought an example, what did I just do? Of how it should be here. It was explained to me that exceptions and modifications are for existing land and parcels, and that's what your zoning book says, that have to be modified, as Ed Teets said, for narrow lots. So here's an exception and modification. There's been a recent passing in our township, and this is the land of record. This property I've given you is a land of record. you will note on the land of record, the one yellow one that's got a long driveway out, there is no 200-foot frontage. This was cut off before zoning ever even was thought about here in the 70s. It's in the trust. If the family would decide to go build on that, this is your exception and modification to your existing zoning law that says, yeah, that yellow lot was a lot of record prior to zoning, and you can build on it. And if it's kind of narrow, it's like 200 feet. Or if I would put a house out there, I'm already in a predicament where I might need to get a variance or a difference on my original plan, because I can't really fit it in that area, because maybe the terrain or something. That is when an exception and a modification would be applied here that would not be in the 25, 50-foot setback necessarily, because you've got a lot of record prior to the zoning, not new construction. Now you're trying to apply a part of your zoning law that allows for exceptions and modifications to a new construction to a person that originally said, yeah, I'll follow that 25-foot setback, and now they've changed their mind. And the zoning administrator changed his mind. After he said it was going to be cut off, 6 months later, no, we're going to allow it a little bit because my predecessor did. Nobody ever gave me in writing why that was all of a sudden allowed, and it wasn't allowed before. I was told it was going to be cut off. So this is why we're here. And then we sat and waited. You've got pictures in there, and it shows you from 2016. It shows you on picture number 4. Deck is not enlarged. He got a permit to enlarge it. And Ed Teets said, yeah, he had a permission to enlarge it, but was it legal? Was that permit legal? Did it go into the setbacks? I don't know. I need a copy of that to see if that permit to enlarge it was legal. And the way that house lays out, it would be okay to run it up to the north and still observe the 25-foot setback. It would not take away from the beauty of that home at all. If I wanted to enlarge my deck, I could even come out back if I wanted. I do not need to encroach in that 25-foot setback. But after a meeting with Ed Teets and Chris Gaines, we decided we're going to stick it out there. That's not right. That's not what's in this book. So the permit that he pulled had expired, and he had not added that addition. You've got 1 year, according to your zoning laws, 1 year to put that addition on. Did not happen. With the county, it was not filed with Butler County. Butler County has 0 permits for it. I talked to Rebecca on Friday, and she said, anytime you move any stick on any property, you got to get a permit. She said, there are no permits available for this guy. There are no permits on this house, other than the initial permit that was applied for. And my question is, how come the county's got a permit or got a drawing that sits out 10 feet into the setback area, but the Board of Health, and I haven't seen what you guys got, honor that 25-foot setback? What the Board of Health has is what Chris originally submitted for his plans, which honor that 25-foot setback, because I was told he knows the zoning code. He'll cut it off.
I can't stand or I can't represent what the Board of Health has or does not have. I can only represent what the township has.
Is it honoring the 25-foot setback?
We are honoring the 25-foot setback.
I mean, the drawings that were submitted. How did it change from here to up there?
I don't understand that question. The plat drawing shows a 25-foot setback.
Okay.
on the legal description of the build.
Okay.
And that is still being enforced and complied with.
Okay.
That I see. Per the measurement that was made, I see 25 foot to that piling. And if we look at the...
To the piling, you're right.
To the piling, right.
Yeah,
And then if I look at that 3-foot deck overhang, if I measure that, if I go out right now and measure it, and I see 3 foot, the zoning department is complied with our guidelines. Would you agree with that?
I agree with that, because
And-
this is a new construction. There are no exceptions and modifications for new construction.
Okay,
Not in your book.
okay. I'm gonna turn to our zoning director here. And under new construction, or if that were a new construction, it would be 25 and 3, correct, Bill? If it were an existing structure, what would it be?
The same.
25. So
mean-
either way,
I
it,
disagree.
it would match, it would be the same. I don't know, I'm not a builder, so when I look at a new construction or an existing construction, it's the same to me basically when I look at setbacks complying with the zoning guidelines.
If it
So-
was 25, it should be, if you're gonna have that like that in your township, you just redid the zoning.
Change all your
25
setbacks.
foot, yeah, change.
Change it.
How would anybody know?
We were told no exceptions. We were told no exceptions.
So you're,
Okay.
wait a minute, say that
You're
one.
saying now it's 25 plus 3, so it's 28. It's
No,
not
it's-
No,
25.
22.
22.
22.
No, it's 25 setback. They can go 3 feet beyond it, right?
Right,
Yeah.
right.
They can go 3 feet into it, so it takes away that 3 feet, so you're at 22. So you need to change it to everybody now can go, yeah. So that's why it's at
Well,
25.
you know, you can't say, you really couldn't say that because if I want a 1-foot overhang on my deck, you know, then you could say a maximum of 3 feet overhang. I think that's what you're trying to say, right? 25-foot setback with a maximum 3 feet overhang.
So the setback isn't 25 feet, it's at 22. Yeah, it is.
You have to look at what's attached to the ground. That's the peg. That's what you're working to. That's what you're set.
Okay,
That's where
then what about in this drawing here? That would be your reference 14?
right.
Now,
Right.
that is a problem,
No.
because that is
Yeah.
attached to the ground.
Let me try to help explain that. On the guidelines, if a staircase, or I think that's one of the structures that was cited, if it's not attached to the ground, if it's movable, then it doesn't encroach into the setback.
This is movable?
If it is not attached, those stairs are just setting on those pavers, then it's not movable.
Looks attached to me.
Now, you might want to cite the right chapter
I
and
can-
verse, Dale, if you've got that handy, and let's get that nailed down.
Well, I'm going to talk about the overhang first of all. I mean, from what I see in this particular certificate that was approved by him, it says at the bottom, extending the deck to master bedroom walkout on new construction.
I have no problem with that. If it goes straight north, it's not in a 25-foot setback. Is there a drawing, an illustration with that?
There is none.
There's
I'm
supposed to be.
sorry, there is
There's
none.
supposed to be according to
I
your
know,
zoning code.
but this was 2016, it's all I've got, Susan.
Not
Okay.
following the code in 2016 is no different than not following the code in 2005. You're not following your code.
I know that. I can understand that.
So that makes it okay?
What makes it okay are these modifications that you speak of, which are also modifications that I have written about too as well.
That's a new construction. Can I back up?
Nowhere
and why
in
did-
those exceptions or in modifications does it mention new construction. It mentions lots of record.
That's a,
He had already built a deck around it. It was no longer new
we are
construction.
twisting the intent of the law. Let me
I
just
think
say
you're
that.
doing the same thing.
No, I'm not. I'm following the law. Well,
Oh,
let me
I'm
ask you
glad you
this.
are.
Why was I not given this? What happened here that we were not served
I'm not
with?
sure. I mailed it. I'm not
I
sure.
see you mailed it. You
I
signed it.
don't even have the receipts. I'm not sure what happened to them. And for
Maybe
that,
because it wasn't mailed?
I'm in wrong. Yes, it was mailed.
No, sir. You can't prove it, so you can't say that. You cannot prove that we got this
Well,
because
I
we
can't
did not
prove
get
it.
it.
I can't.
My
I can't-
neighbor knew we
You
got
need to
it.
prove me that. Okay. How did your neighbor know you got it?
You must have told him because I sure didn't see it until Daryl showed it to me. And I insisted that Daryl give me a copy of it because this is not right, this is not fair.
Well, I'm not going to further that anymore.
Because you can't prove what you just said.
And how did you get it then?
Daryl gave it to me Saturday.
And how did Daryl get it?
I heard it announced from Mr. Gaines stood up and announced that I had it, received it in my post office box.
But-
I
So
have
was
never
it in
seen
your
it.
post office box
Never
all
was.
those years?
No, there was,
How did
no.
Daryl get in your post office box?
But I bumped into Daryl when I went to the post office.
Okay.
Said there was a letter and I.
May
said,
I
"What
further
letter?"
this, please? May I further this, please? When I sat down to look at this,
Mm-hmm.
because I received your letter, and I was replying to your letter of that particular time. This was
You
all,
mean back in 2018?
yes,
Okay,
back in 2018, I was replying to your letter.
okay.
I did some very good, what I thought, deep research on this. And it is within those modifications that I came up with the reference to the 19 point.
A new construction, can you show me where new constructions are allowed modifications and
Can
exceptions?
you show me where it says new construction in this modification on this, in this exceptions
It's a
and
new
modifications?
construction.
Where is it? Where does it say not new construction?
What's the date on that?
This is, well, it says new construction on this.
What's the date on that permit?
That's 2016.
Okay, at 2018, that construction had never started. Therefore, that certificate you're holding in your hand is null and void.
I was unaware of
According-
that.
It's in your zoning laws here. It's
Excuse me, wait a minute. I know the zoning laws, yes, and I know it expires, but I was unaware that this had expired.
All
And
your
knowledge
permits say
is.
1
and-
year.
1 year.
Well, I didn't know that it wasn't built in
Is
2018.
there no inspection on any of this stuff?
No inspection?
It was built,
I got picture proof dated.
I'm sure
Fine.
you do in your thousands of pictures, Susan.
Yep, so, you prove it different. Prove it
Okay, so,
different.
so
So I
let
came
me
in,
talk about the inspection. It is, we will inspect the setbacks on the township side, and that's what we have done. We have inspected the setbacks. Now, for this letter, what would be the difference? What would have changed if you had gotten this letter when
I
it
would have
was?
been here the
when it
next
was-
day.
About what? And what would you have done?
It's not an exception and a modification on a new construction. I can't find anywhere in any state, I researched Nexus, Lexus types of searches, I see nowhere where an exception and a modification. Usually, if you want to change something up front when you're doing a bill, it's called a variance. There is no variance. It's a new construction. He said that he knew the 25-foot setback and he would honor it and he was gonna cut it off. We were told that up front when Ed Teets first went in there, and then all of a sudden it changed, and when I asked, where did it change in here? I just don't always enforce it. That was the answer we were given. We are not being treated fair, and this is not being
Okay,
enforced fair.
Mr. Teets is gone, and 2016 and 2017 are gone.
That's not right, what's being done here, though.
That, we comply with,
Thank you, thank you.
we comply with what we have now. If we can correct something that we have done wrong in the past, we will try to correct it. But I'm not sure what we can correct. What is it that we would correct to suit your concern?
Cut the thing off at 25 feet. It could be a beautiful deck going straight out the side. Excuse me. We were told it would be cut off at the cement pillar at the 25 feet.
Who had told you that?
Ed Teets, good. Let me
Okay.
give me the exact.
Okay, so,
Give me the exact, I'll give you the exact thing.
so
Oh,
I
no,
don't.
it's in your email. You got the email there where he said it, in writing. He said it in writing.
If he said we cannot comply with something he said in 2016 that violates our zoning guidelines today, that's where I'm getting stuck. Because if our zoning guidelines say 25 foot with a 3 foot maximum overhang,
No, that's not what we were.
I can't enforce cutting a deck. We can't enforce that.
The 3 foot overhang you're referencing is in exceptions and modifications. We were told at that time, and we were told recently, that only is for lots of record that were grandfathered in before zoning that has situations like your narrow driveway there. That is where exceptions and modification, it is never used on new construction is what I was told. I've never found any place where it has been. It's a distortion and a bastardization of this zoning law to try to twist it to fit something that does not comply. The
Okay.
original building was with the 25-foot setback being honored. That's what was originally, and Ed Teets would not have signed off on it with the 25-foot setback. He signed off on it originally. After they got together, all of a sudden, the law starts to morph this into something that I don't know and I don't recognize in this book. I have studied this book hours. This goes back, I started studying this book back in the early 2000s. I know it's in this book. And I was told, no, it does not, that's only on narrow lots when we have lot size issues and we need to make adjustments and everything, not on new construction. And his permit is on new construction, and his permit says 25 feet. His drawing says 25 feet. And I go back to the thing, how come it says 25 feet and all of a sudden when it gets up there now it's at a 10-foot stick out on the drawing up at Butler County? Only one permit. He was supposed to get a permit to do this, to do the enlargement. There is no permit on file.
I think did he not get the permit and
No.
then he came within, it busted the time limit on the permit?
He's never gotten
Don't-
one from Butler County, and it has to go through Butler County. Once it leaves here, it goes through Butler County. Butler County has no permits on anything, anything. Look at it, look at the drawing I gave you from the auditor. There is no deck extension. Now, that deck extension was put on and added by, it was there by the, date of September 2018. That's when he put the extension going north with a second stick out, that sticks out into the encroachment. And that has never been put into the auditor's page and on the county, because there was never a permit for that
Okay.
change on that drawing. Never was authorized. I mean, and pictures don't lie, I'm sorry. I can tell you I'm 10'4", but, you know.
Okay, go ahead, Chris.
Chris Gaines, 6875 Hamilton Scipio Road. Morgan Township zoning application for zoning certificate for the deck was done on 9/8/16.
Right?
Why would I wait 2 years from your recollection to build my deck?
Well, let's look at the pictures.
On top of, why do you have more pictures of my house than I do?
It is a free country, I can take.
I'm
as
not
many
finished.
pictures. Oh, okay.
Also, we're talking about 3 feet from the property line. What is next to my property that is so important that the 3 feet that's allowed has got your panties in a bunch?
Excuse me, Chris. It's not the law, and you don't
No,
have to,
answer
you
my
don't
question.
have to be insulting.
I'm not insulting. What has got you upset about my deck being in compliance 3 foot over the 25, because the 25-foot setback is measured from the columns, from the posts? Yes. And I'm going to bring that up because if I had not taken the wood deck off for maintenance and put a composite board on there, 7 years later, would we be sitting here in this meeting today?
Did you get a permit for that?
You don't need a permit for maintenance.
You call Butler County and tell them that, because that's what I was told. You move one board, you gotta get a permit.
You do not need a permit for maintenance.
To answer your question,
My question is, what is so important next door to me on lot 5 that the 3 foot allowed overhang has got you in a tizzy?
I'm in a tizzy because zoning is not being followed.
No, answer my question. What, it is being followed, so what is your let me restate the question. What is your problem with me?
I don't have a problem with you, Chris. I'm here for a zoning issue. that's
You
not-
have a library of paperwork on me, pictures of my house. My daughter came in running from outside scared because you walked through the backyard taking pictures.
When was that?
Years ago, because everything.
When was that?
Years ago.
Give me a date.
I can not
Okay.
talk about any one of
You
these
weren't
pictures.
home when we were taking these pictures.
Let me interject. Chris, hold on a minute. Wait a minute. May I say something? Ho. If
No,
the
she stays
audience,
on her property.
Chris, hold on a minute. If the audience cannot contain,
Thank
we're going to adjourn the meeting, okay? This is not a group participation.
Well,
This
for-
is,
Sorry. Yep.
this is an official function that we're trying to hear these two parties, and you're here as concerned citizens, not representatives of anybody, okay? So please just keep that in mind and be respectful.
But as a concerned citizen, is it their right to come up here and state their name on record and ask questions or?
If they're
comments?
recognized from the board.
So if you have something to say in the audience, please come up to the podium, announce your name, your address, and then your comment.
I think we'll take care of that.
Thank you.
All right.
The other question is, how far away from my deck do you live?
Got nothing to do with it, Chris.
So you're not going to answer the question?
Chris, we pretty much,
Okay.
we
That's
pretty
fine.
much got to,
It's got nothing to do with it. That's
Mrs. or Courtney, are you gonna,
Courtney Gaines, 6875 Hamilton Scipio Road. I have a question for you. Do you have any current infractions on your property at this time?
That's not the issue here. We're talking about a zoning enforcement.
We are.
issue.
Do you have any infractions on your property at this
No, I don't. You
time?
mowed down all of my milkweeds for my monarchs on Sunday night, trespassed on my property. So, yeah, I have nothing. You mowed our grass that should
Do you have any infractions on your property at this time?
Mrs. Gaines, we will address that. Let's finish up this part first.
I
and then-
understand. Her
and then
point
we'll
is that
go ahead and do
laws are
that.
not being enforced, okay?
I know.
We
I
have
know
proved
they
that they have been complied, right?
I understand.
So I just would like to make the point that other laws are not being enforced by the complainant.
Well,
Duly noted.
duly noted.
Thank
yes.
you.
Okay, thank you. Okay, thanks, Chris. Okay. Now, we're back to the permit. I think that's, we left it as a build without a permit. And I think Mr. Gaines explained that he did have a permit.
But it
He had a
expired.
permit for the build, and it's pretty well concluded that there is no permit required for maintenance.
May I make a clarification here? First of all, the zoning department here at Morgan Township does not issue permits, it issues certificates of approval. The building permits are done by Butler County. So if you're going to talk about whether or not Mr. Gaines had permission or proof and met what he states in the certificate that he was approved for versus the building permit, please do it that way. Say certificate. To me, that is the understanding. This only says that Mr. Gaines is permitted to build as stated in here on the setbacks issued and everything else, and we approve that. He go
And
ahead and build it. It has nothing to do with the construction or building permits that are officially given by Butler County.
Dale, do our zoning guidelines explain the new construction versus existing construction that Mrs. Susan is talking about, that we can explain our guidelines with those two criteria if they are being questioned?
Not really. It doesn't give a definition of new construction, okay? But it does give I believe, a definition of existing lots of record.
Lots of record.
But then new construction or existing would not fall into our purview anyway. That would be at the county level. So,
And that's a good point, but you approved new construction honoring that 25-foot setback.
we provide a certificate, as
You did. You provided a
Mr. Marshall
certificate.
is mentioning.
And he did reference that certificate we go back to is good for 1 year.
Yes.
So the pictures that we have here, that construction to enlarge, and as I say, I don't care if they enlarge it, I just don't want it sticking out there. But to enlarge that had expired before this certificate. This certificate expired before that was done.
That is knowledge that I did not know. So I can only reference
And
what I know.
I don't care if it goes to the north, I really don't. I don't want it sticking out because it's having a negative damage on my lot 5. If I would ever decide to sell it, it has a negative effect.
But you don't want the deck sticking out, correct?
In that setback, no. You don't,
Oh,
not in
okay.
the setback.
But that deck would not have any consequence other than to the person who owned that property and built that was in compliance with the zoning guidelines. All of us have neighbors who have done something that says, I wish they wouldn't have done that. We all do. Now, if Chris, Mr. Gaines, puts a deck there that one of the neighbors do not like, no one has a recourse to that. That is being a neighbor. So I don't know how we can rectify your being offended by that deck
No, I'm
being
not
put
offended.
out
No,
there.
I'm not offended. That's not a good word. I'm not offended. I'm upset that the zoning is being twisted and not being utilized with the intent of the law. The intent of the law is 25-foot, I was told, 25-foot clearance.
Okay.
Clearance, open clearance.
Okay, one thing that I can help explain is, we record these, and we record the minutes to this meeting. When we go back and print the minute, write the minutes, we'll address the concerns, because it will be much clearer to sit down and go through all the issues that you've brought up and address them, because that's the only way I think we can provide you satisfaction and Mr. Gaines satisfactions to the issues you brought up about the zoning. Because it is a complex issue when you start talking about guidelines and regulations
And they're not being followed.
with no pictures.
So I have one question, and to spin off of what Chris asked you. Nothing changed as far as the footprint of the deck, other than the addition of the steps, correct?
No, that's,
I
no.
don't know that. We didn't.
Not with the
Okay.
drawing you've got.
All right,
This,
so if he had not decided to do maintenance on his deck and replace the pressure-treated lumber that was originally installed 7 years ago, would you have an issue? Would you be here tonight?
no.
Okay, so what are you claiming has increased the footprint other than the steps? The steps we'll bring up later, but what,
Go ahead.
the footprint of the deck?
The deck.
Anthony
the-
Turner.
Anthony Turner,
Weaver.
Weaver Road. The deck that he says that he's refurbishing has never, as far as we know, I mean, you can see the temporary, it never had a rail on it. There was nothing there ready to
You
make
see all the
that, I
pictures?
mean, the kids or nothing could come out on that. You see those pictures of those rails? When he got his cutoff date, whenever that was, they stopped working. There's never been anybody on that deck. I've never seen anybody on that deck. Only when they built the house was the only time I saw them on that deck. I'm hoping you're not thinking that's funny. But anyway, until now, that deck had never been touched, other than tacking up a board once in a while. We got, every year, we were just waiting to see,
We've been waiting.
after Ed Teets said that he was gonna cut it off, and Chris Gaines knew what to do.
He knew the zoning.
He knew zoning.
And he would cut it off.
That
After
deck sat
25
like that every year.
Could you, Dale?
Well, I'm looking at September 7th, 2018, your photo number 8. I'll give you that it never had a railing other than a temporary railing. Is that correct, Chris? But it looks to me like that's a grill on there.
That grill's been there since day one,
So it had to have some sort of flooring, right?
and it's never been hooked up either.
It has a floor.
It has a propane tank.
No, I mean, they got a, never mind, that's not.
No, I'm just saying, if he replaced the floor from pressure-treated lumber to composite lumber, did he really increase the footprint of the deck? I think that's the issue
I
here.
don't know I don't know, because it's not been measured. We don't know what it is.
You have pictures to go by.
Pictures don't measure anything for me.
But you just said you
Chris,
go off,
Chris, come up to the,
you go off of a website to measure how far my deck is from your fence. But you just said
No,
you don't
no.
go from pictures to measure?
I can only guess.
My setback, I think what they're having a hard time understanding is where the setback is taken from. The setback is taken from the post. That's at 25 feet, as measured by Ed Teets, as measured by Dale. That's where the setback is taken back. The overhang is within the 3 foot. You'll address the stairs in a minute. What am I not in compliance with? Regardless,
I'm not sure.
regardless
I'm not
if
sure.
I didn't have a handrail
Hold,
or
Chris, Mr. Schulteis, maybe this comes to you. What did Ed Teet,
That's all right. That's all right.
oh, I'm sorry,
Yeah.
Mr. Turner?
Yeah.
That's all right.
What did Ed Teets want, you said that Ed Teets said that Chris would cut off 10 feet of that deck.
It's in
No,
agreement.
well, it's whatever. I don't know how much he would cut
He would
off, but
cut
it
it
would be
off
taken back to 25 feet.
25 feet. And T said it in your
it's in-
email.
so they're.
But,
they're
yeah,
just
but I'm seeing it now. I think,
misconstruing-
I'm looking at the old pictures, and I
Right.
don't see, if you take
The-
10 foot off, you don't have a You don't have a deck
If
anymore.
I take 10 feet off, the deck isn't landing on the beam.
Uh,
It would fall if I
Well,
took
you-
10 feet off.
No.
I don't even think, well, how far out does that deck go? It doesn't look like it's going much more than 12 feet, maybe.
It's less than 12 from my bedroom to the corner of where
Okay.
the roof overhang is.
Okay.
From the roof overhang, there's a 45 that juts away from lot 5 because it's 31 feet away from the corner of the house is 31 feet in the front corner, and then it's I forget what the back corner is, but that 45 makes the deck that's over the roof overhang elongated. It's longer back in that section versus the section from where the roof overhang is to our bedroom door.
Okay.
We're not asking for 10 feet to be cut off. We're asking for it to be cut off at the pillar, because that pillar is where the 25 feet is. And that's what we were told would be cut off. And that's what Ed Teague said would be told. That's what and it's in writing. It's in writing. I'm sorry. I don't
Okay.
make this stuff up.
Okay. Yes,
Courtney Gaines again.
yes.
Aside from all of the extra information and questions, are we out of compliance?
I don't,
As of
I have looked at
measurements,
the pictures. I have looked at the setback.
they
I
are
see the
measured.
3 feet, if that's a 3 feet overhang, which our zoning administrator says it's a 3 feet overhang, if you meet those, it complies with the zoning guidelines. Now, Dale, am I on solid ground there?
Yes, sir, you are.
I can't be any more eloquent than that. That's just by putting numbers together and looking at a picture and a tape measure and seeing, does it meet? It looks like it meets to me.
My only concern is, I have lived in this township all my life, and I have seen zoning administrators mislead their trustees, and I don't like that. That is not a good idea. So I would like to really make sure you trust who you're listening to, because I observed one time, Ed Teach stood up and said, oh, pools don't require a fence around it. It was in the zoning, pools did require a fence, and then he said, and Butler County doesn't, I told Darryl about this years ago, and Butler County doesn't require it either. They do, it is in the zoning. And the trustees looked at it like, okay, because you trusted the people that you were listening to. And I would just say, I don't like that when people take advantage of your trust.
But you're
There's,
listening
the-
to-
really, the concept here is, you have people, we have jobs to do,
True.
but we always consult the ORCs and the guidelines and the laws to validate. That's why there's 3 of us.
I appreciate
That's why there's 10 on the commission, the Board of Commissioned, and there's whatever on the BZA. All of those people are very well qualified. They were selected because of their qualifications. We're always cross-checking that. So there is in my opening statement, that there is no zoning that goes unilateral. It is always overseen. So I would want people to have confidence in the zoning. I would not want a meeting where people walk out of here and say, hey, your zoning is out of control, because it's not. And we always have a forum like this to come to debate this, which is what we're doing now. So,
Well, we still got an issue of a deck that's been expanded and built, and it's not certified, it's not registered with Butler County, there is no permit with Butler County to even have this happen.
Let me address that if I would. You have our permit from Butler County that's expired? Do you have that in your paperwork
For what?
for our house permit from Butler County?
No, the permit from Butler County is an open to build new, you renewed it, and then it's closed when it's finished. So
Okay.
your house is finished, got nothing to do with the deck.
But the deck is attached to the house, the permit's closed and finished.
Yeah, for a little 10 by 12 or
Okay,
whatever you had
so-
originally. It's not what's
Okay,
there.
so let me clarify for you. I went back into Butler County after I got my approved addition from zoning, because I had to take that to Butler County to get a permit for the deck on the new construction. I handed that to them in 9/8/16 was the date. I handed that to them because I was still building, because I built the house by myself. You have pictures of that.
So you're saying
I
there's
went-
another permit?
There was no permit because they said you are still building. We will check your footers, because that's all they do is check your footers when they come and pour them. They came and checked my footers when I poured another section of concrete, said you meet your depth requirement for your footers, you're good to go. I didn't need a permit because I was still continuing to build on the house. That's what I was told. So if we're going by what was told, just like you are by Ed Teets, that's what I was told.
Have you seen this on the auditor's page? Do you know this exists?
Do you know that the auditor's page is behind? Do they have my driveway? Do they, like anything you go by, like Google Earth is a year behind.
No, we're changing the subject.
We are, we're going round and round in circles on something that's
Have you seen
approved.
this?
Can I ask a
Susan, can
hypothetical
you
question
get
for
closer
Susan,
to the
please?
mic, please?
Your mic, you got one right there.
I thought he wanted to see it, that's all right. What was,
Go ahead.
according to what is on the auditor's page, which is years behind, but they've got this right, because it's
Sure.
based on your original permit.
You
It
just said
has-
it's years behind.
You said it's years behind. I just, it has a 10-foot extension on top of a deck that already exists, and it has nothing coming up the side. You guys got this picture. And that's what I'm saying.
May I just ask you a hypothetical question? Let's say we measured the deck, it is 3.5 feet overhang. Okay, and to be in compliance, we would have to cut off 6 inches. And we went home today and cut off 6 inches. Would you be happy?
I don't know.
Would you stop
I'd have to
coming
see
up?
it- I would have to see it first, but I'm,
No, because I'm just hypothetically saying, if this was 3 feet 1 inch and we went home and cut the 1 inch off, would you stop with this?
what you fail to realize, Courtney and Chris, I am not here because of you. I'm here because we have been told one thing about zoning, something else about zoning, and something has
And this
nothing to
is
do.
something,
You could be Mr.
hold
and
on,
Mrs.
this is
Magoo.
something
It
I
has nothing to
absolutely
do-
agree with you on. I am 100% with you in staying within those walls. Your fence is on our property.
No,
You've
it's
been
not.
asked to move it.
Prove it.
I,
No, prove it.
I'm just saying,
No.
I agree with you that certain
That's-
laws should be met.
That's a red
The
herring.
posts that show
No.
our property line, your fence is over.
No,
It's
not.
also on the wrong side. You were given 90 days to change that and comply with that law 5 years ago. I could care less about your fence, which is why we've let it go.
Chris and Courtney agreed in mediation to never bring up the fence again. That was
We
in
might have, well,
court mediation. Now,
no,
okay.
listen. Even
We-
if we
we are
did,
not
the
here-
township has asked you to fix it.
We're not here for the fence, the township's after you for the fence.
no, the township's not after nobody. The township is not after. That is a red herring that keeps getting thrown out here, and if you want to schedule another meeting to discuss the fence, I will be glad to come back.
My only point in bringing up the fence is that I agree with you that laws should be complied with. We are in compliance with the township laws of a 25-foot setback and a 3-foot overhang.
No, you're not.
Okay, and if we are not, let's say we go home, measure, and we're not, and we cut that off. You can't say anything else about it. We're in compliance. That's my point. And I apologize if you're upset about it. For whatever reason, the encroachment that you think we're trying to do,
No, I'm not upset.
clearly not upset.
I came prepared for the fence. If we want to go
We don't
there-
need to talk about the fence. My point in bringing that up was that I agree with you that we all need to stay in
Well, you just made
compliance.
an allegation that the township is after me over the fence, and that's not true.
I'm not making an allegation. I'm stating
No.
a fact that the township asked you 5 years ago
No, ma'am.
to fix your fence within 90
You had the court
days.
ruling for the-
No, they did not. No.
We deny
Show me.
We deny that. We deny that
Jeff.
vigorously.
Let me,
You want me to go get mine or you
I
want-
got-
no,
I
let
just
me,
gave it to him.
let me just review a
Let's
couple.
try to resolve the one.
Things. I was able to speak to the prosecutor this morning concerning this, and I think there's one, this is on the stipulation of dismissal. What this is, Is that one,
I
Mr.?
get a copy. You want it, I'll give it to you.
No, I have it.
has a
I'm going
copy
to
of
read
it.
it. That Mr. Bennett, and that's what I had hoped we could resolve tonight, is because we've got some concerns on both sides. And it's either going to be a struggle or an ability to cooperate with each other. But this was a stipulation for dismissal. Approved by came down from the Common Police Court, and it states that Morgan Township, us, and Mr. Turner as the defendant, it states that upon agreement of the parties, this matter is hereby dismissed without prejudice, which means that it can be refiled if it is not complied with. So there was a judgment here, and your attorney had attempted to work it out. This dismissal was based upon defendants' representation that they intend to use the property for agricultural purposes, and that the fence would, upon commencement of that agricultural use, be a structure incident to the use of the land for agriculture. If defendant fails to begin use of the property for agricultural purposes within a reasonable time, plaintiff intends to pursue enforcement of the requirements of Section 6.9 of the Morgan Township zoning resolution, each party to bear its own costs. So there was an agreement between your lawyer and the court to go ahead and complete that fence. Now that's notwithstanding the fact that the fence, from the pictures that I saw, was spot on the survey mark, which means that it could not be there. It has to be moved. And the fence has to comply with the zoning guidelines of the fence has to be on the outside of the post facing the adjoining residence house. So you have a post on your side and the fence on the outside. Right now it's reversed. Now I'm just saying that because that's the state of affairs right now. And that's something that you will have to deal with or we will have to deal with if you can't reconcile this. So the ball is in your court. Do you want to keep pounding, or do you want to cooperate?
Never did a thing about it.
No. This
All the way through, our lawyer was dismissed before the case was over. Jay Bennett wasn't even there for the final signing.
Okay,
I
well
don't
he's
even know how you got that.
He's representing you on July the 28th, 2017, and it comes from the Common Police Court.
Okay.
And that's all.
The fence
Mr.
issue
Turner,
was
that's all I know
fence
is what I
issue was
read.
settled.
Let me handle this.
Okay.
You received the handout I just gave you,
I believe I have that.
okay? And it
Is
says,
that
this is
the,
the original lawsuit against us.
Is that with the plaintiff is Ed Teets
Ed
and the
Teets.
defendant is
Absolutely,
Mr. Turner and Mrs. Schulteis?
yes.
Okay.
This is
Dated
it.
2017, case number 2017-03-0681.
Absolutely.
Got it.
Okay, I did not, and we'll spend as much time as you want. Ed Teets lied about our property. In there, you will see on number 4, it says, buy a residential lot using barbed wire on the fence. First of all, there's never been barbed wire on that fence. Never, ever. And we are not residential. We are zoned ag, and we've always been ag since we've been up there. Nothing in your zoning book applies to ag. I'm sorry, you can't tell us what to do with the fence. How many farmers out here have fences? There's a brand new fence just got ripped out from around the curve, Lehigh and Robinson Road. They don't have animals in there, but they put the farm fence up with the finished side on the inside to make it easier for them to mow, and you have no jurisdiction over where you tell them to put the barbed wire or whether they put animals in there or not. I have researched this inside and out. So if we want to go there, your zoning administrator lied because the attachment that he gave to this lawsuit, he lied to the courts and misrepresented our property as residential, and we are not.
All I can say.
I'm just
is that-
straightening out. I'm
is that-
trying to
no,
get
no,
the
no, wait a
record
minute.
straight.
Wait a minute, this is not
I know.
us.
I'm just saying-
This is between you and the court. I'm just reading the judgment.
We are using it for ag. We have always been ag. We are a farm. So if you're going to go after us and apply a residential law to a farmer You gotta do it to all the farmers out here, and that's not right. You can't do that.
When was the last time you read this document? I'm
I
sure
read it in detail, I just gave it to
Okay.
you.
Did you see where it was based on the completion of that fence? That you had a limited time?
We can't
to-
complete the fence. And you
Because of
can't
the-
tell us
because
what
of
to
the-
do with our fence.
Well, I'm just digging facts.
I'm-
Was it based on the water? Was it based on the water flow? Because I know in the judgment, in the stipulation for dismissal, it indicated that there was a water concern, that there was water being shed into your property that created an agricultural hazard for animals to be on that property. And that's why
That's
the
got nothing to do with this.
Yeah, it does, because I think, I think Mr. Gaines addressed the water flow issue, did you not? With a, okay.
So when you
So-
sued us for our sump pump water runoff, we had mediation with that, right? And there was a judgment that was dismissed with prejudice, and you got paid $2,500 from our insurance company to create a head wall to gather the water to eliminate the problem. Have you used that money to create a head wall or do anything with the back corner of that lot?
If you look at number 7 of the pictures, you can see that Chris did not do what he said he was supposed to do with the law and divert all of his water to the back pipe. He has not. He's pumping it out front. So that's that's litigated out of court. That's got nothing to do with you guys. You said you had nothing to do with water rights and water issues.
I have
got
another
nothing to do
question
with it.
about being residential or agricultural. So if it's only an agricultural lot, lot 5 with the pond, would we have had to change it to be a residential lot when we were under contract for first right of refusal to purchase that lot? Or was that zoned resi-
He said don't answer.
There's- you don't
Yeah,
know
don't
what
answer.
you don't know.
Okay, I'm just curious because when we first purchased lot number 4, we had a first right of refusal to also purchase lot number 5, which is where the fence adjoins and where our deck faces. So our entire plan in purchasing both lots and intention on purchasing both lots was to incorporate our house into the middle of both lots. So we got as far over as we possibly could within the township laws, 25 feet deck-wise. We gave ourselves enough room for a deck without encroaching, okay? Because at the time, we could not purchase lot 5 outright. We wanted to make sure we had enough money to build the house and do what we needed to do on lot 4. However, the first right of refusal gave us an opportunity that if another purchaser came through, they would tell us and we would have the opportunity to purchase at that time. Before that time was up is when we went to court over the water runoff. We weren't in contact at that time, which makes total sense, but our time ran out on the first right of refusal before we had an opportunity to purchase. So,
What's that got to do with anything?
because you're claiming it was all agricultural.
It is, still is.
So my question is, well, if we had purchased it, right, it would have been an agricultural lot, not a residential.
You have to ask the auditor. You have to ask.
So is
you
my
have-
lot agricultural under Butler County right now?
Oh, no. Once you put a house on it, it's gone. It's not.
I beg to differ. I beg to differ.
Huh?
They are zoned
They're not
agriculture.
CAUV. Let me correct it. They are not CAUV.
All right?
Taxes.
That's just tax purposes. Has nothing to do that says that you're agriculture, zoned agriculture.
Is the lot with the pond, lot 5, is that part of the bigger parcel of your quote-unquote farm?
That's got nothing to do with this. You see, they've got a copy. You see what our property is zoned as. They're all ag. They're all CAUV.
Mine is ag. Mine is A1.
And Mr. Schulteis, you're farming that property right
They
now?
just baled a bunch of hay off of it. And it doesn't matter. It's connected to the bigger parcel. And once a farm, whether they split off.
It's not connected.
because
It's
I
a
know-
separate parcel.
I know in the judgment, it says that it would be considered agricultural use when that fence was completed.
With animal
It's always been.
husbandry.
No,
It actually,
No.
it does,
not in
I'm
the
gonna-
no, you got a copy of the final. You got the copy of the, it would be used for,
But Tony's never seen it.
no, he's,
I've seen
it doesn't say anything about, it.
well, the additional judgment stands, a stipulation for dismissal says that the case is going to be removed based on you complying with the original court decision. And it did state in there and I could read that for you, but I think it would probably be no value added at this point. So where we are right now, Mr. Gaines is in a situation where he has got to comply with the zoning laws, and we will enforce the zoning laws. And as far as that fence is concerned, the fence, if the judgment is not met, then we will have to refer that back to the prosecutor's
We'll
office.
take it to the state of Ohio, because I've talked to a lawyer at the state of Ohio that teaches ag law, and she said it is ridiculous. You guys, if you read, and this is ORC also, if you read in your zoning laws, nothing in this book, you're going after us, go after us, because we're an ag district. and
Here's
you-
what I'm saying, this is not worth it to either one of you.
It sure is not. And it is out of compliance with your zoning law, and that's why I'm here.
Okay.
I'm not here because of them. I'm here because this is not being followed the way it's supposed to be.
I appreciate both of you saying this is not a personal issue, this is
No.
just a very factual, by-the-book issue. And we will comply with the zoning, make sure that zoning guidelines are complied, and that will mean certain things to certain people that they have to comply with.
Okay, when Ed Teets misrepresented our property and called it residential when it is not, it says right here, 6.3, nothing contained in this resolution shall prohibit the use of any land for agricultural purposes or the construction and use of any building or structures, which would be a fence also, include incidental to the use of the agricultural purposes for the land on which such buildings and structures are located, and no zoning certificate shall be required for any of these uses, buildings, or structures. Now, when Ed Teets misrepresented and lied and says we were a residential lot, section 4 of the original lawsuit, that was defrauding and misrepresenting the courts of Ohio. You cannot say something is a residential lot and it is not.
Are you saying that if a farm fence can be constructed in any way you want to construct it?
No, it's got to be a woven wire farm fence, but it can be with the wire on the inside, because if you got animals in there pushing against it, you don't want it to bother. But you guys have no say over that. That's what I'm trying to explain to you. You have no jurisdiction there, because a farm can put a fence in and where they want and put animals in and where they want when they feel like it. This was invalid the day it hit the courts because it was lied. We are not residential.
Were you in the courtroom when were you present, or was your lawyer present?
My lawyer was present, and we trusted him, and that was a big mistake too, because he wasn't very truthful with us. That's why we let him go. So, no.
How in the same meeting do you praise Ed Teets by telling me everything about my deck, but in the same conversation, you're bad-mouthing him?
Aside from
I'm
that,
stating the fact.
Let me ask one question to Dale concerning agricultural fences. Do they follow the guidelines of the township?
No, they don't have to.
They can be.
I will
they
agree
can-
with Susan
I-
on that. I mean, I've had a gentleman walk up to me and said he wanted to put a fence in. And Daryl, I think you might remember this because you were the guy who told me he was a farmer and he was agricultural and I couldn't do anything about it. On an agricultural fence,
Thank you.
zoning cannot touch it in terms of that. I will agree with Susan on that. That is no problem. I would never have said anything about it. But the thing that bothers me about this is the fact that if you were to make it animal husbandry, which is what I'm seeing there and reading there from that point, and I'm only making this as a point of just that's how I see it, Susan, is the fact that you put the fence down the back of his property and then turned the left and went straight to the road. If you were going to put cows on there, why didn't you enclose it?
I ran out of money and it wasn't worth my effort anymore at that time, but it's our business.
I know it's your
a farmer's business.
I know it's your business.
We
but-
don't have to.
Okay, so based on the fact that everything else, I mean, I clearly see that there was no barbed wire on that. I agree with that one, and I've told the Gaineses that, and I've shown them that it isn't, because when you clipped those little round,
didn't. We had it installed.
whoever your fence man was, that made it look like it was barbed wire to Ed, and I went, no, that's not barbed wire. I mean, I grew up near a farm with my grandparents and stuff like that. I knew what barbed wire looked like and everything else. And by the way, one strand of barbed wire is allowed on an agricultural
is,
fence.
absolutely.
So, you know, it's not that I don't know the agricultural laws and everything else,
This,
And I wouldn't have, and in no way does zoning in Morgan Township effectively zone agricultural land being used as a farm, okay? Whether you have a CAUV or not,
Yeah.
okay? I simply wouldn't do it. If you decided to build a pole barn right next to that fence, I couldn't touch you. Seriously.
that's
For him
what
to
I'm
have
trying to
said that it
explain.
was, for him to say that that was a residential lot, I apologize for that, because it's still an agricultural lot, or a zoned agricultural.
Yes,
Okay? What you've done, though, is that you've split it off,
doesn't matter. Doesn't matter. It's still ag. We're still farming.
all right? But then in that suit, it says that you were going to pursue animal husbandry, and if you didn't do it in a reasonable time,
No, that was some of the stuff that he's talking about. In the original suit, it says residential lot using barbed wire on a fence. And you're citing 6.19 of the Morgan Township zoning resolution. First lie, we're not a residential lot, never has been. We've never been residential lot.
Okay.
Nothing we own is, the second false statement, that's what I'm saying, going forward, this is really bad. To lie to the courts and file, and Mr. Gates or Grosvenor or whatever, he was fed this information, and this is not good. This is not a good look. The property is not being used for agricultural, and the fence is not a structure which is incidental to the use of the property for agricultural purposes. That wasn't a lie.
How is it being used?
It has always been used for farm
How is the-
because it is connected to 92 acres of a farm.
Connected to 5-ish acres.
Don't need a reason, sorry, I'm sorry.
How is it being used for agricultural?
This was not a good look on you guys for filing a lawsuit against a farmer in Morgan Township for having a fence. Not a good look. Not a good look.
It's done. We can't do anything about
But
it. We can't do anything about
don't
it.
keep dragging it up and using it as a red herring to detract from not enforcing the laws here, because every time it's brought up, it is a mistake that it ever happened. A mistake to the farmers, and then I would say, this is part of the harassment that we're dealing with. How many other farmers in this township have you gone to and said, hey, you gotta put animals in that field, or you gotta turn your fence around the other way? How many farmers have been sued in this township for putting up a fence? That's what I wanna know.
This is the prosecutor in the common pleas court that made this decision.
They
to
were
do
lied
this.
to, I'm telling you.
I think it was an issue with Mr. Barrett, your attorney,
Bennett.
if he did not represent you correctly and make sure the truth
He
was
was looking
spoken.
for billable hours, I'm sorry, that's why he's not my lawyer
Okay, all
anymore.
right.
We don't even know about it.
Can I ask her the same question she just asked? How many other residents or farmers have you gone to about a fence? How many other lots have you gone to about infractions?
I'm not
Well,
zoning. I'm sorry.
are
Okay,
you
but
asking
you're
the township-
claiming that
Courtney,
you want all of the zoning laws to be enforced on all the things for everyone, exactly how it says in the book.
Yeah.
We are the only ones that you are stuck in the mud about, even though we're in compliance.
I hate to burst your bubble, but this is not about you.
That clearly
This is no.
seems
Okay,
like it
all
is.
right. We kind of
We're trying to get
put
it
everything out
personal.
on the
I don't
table.
want personal, I want,
We got everything out on the table. We got all four parties in the room. What's it going to take to put this to bed? What's it going to take?
what we were told when we first came.
Okay, what you were told,
But you just
we're here
stated
today.
that
What
Chiefs
what
lied
do
to
we
you.
have to do today to make Susan Schulteis, Tony Turner, Chris Gaines, and Courtney Gaines your neighbors? What's it going to take to, and you said it's not personal, so don't laugh.
No.
Your
no.
neighbors. So what's it going to take to bury this hatchet and move on? What's it going to take? Do they need to cut 6 inches off their deck? What do you want? Why are we here? I know you said,
Is picture 13 6 inches, is that all
We-
we're talking about?
okay, we will go out
I'm
and
not
we will
asking
remeasure
questions
that
and
again.
answering questions
But
with questions. What's it going to take for you to leave us alone for good and not keep bringing us back here year after year after year, taking pictures of our property, scaring our kids, taking pictures when we're not at home. You haven't got any pictures of us out on the
Okay,
deck because
Chris.
we're at home.
Chris,
What's it
Chris,
going to take?
okay, quit with the allegations and insults and,
No,
we want to
there's
just,
agencies taking pictures of us.
we're neutral now. What is going to make it go away? What will make you happy?
What will you do? What are you doing? What
I'll
are you
sell you my
proposing?
property back. Would that make it better? You say we're making lot 5 go down in property value. Put a number on it. We'll buy lot 5.
Hey, Chris, why don't you guys go take a chair and let's just finish up and
I do,
We're-
one last thing before I sit down, hold on.
we're going to get the
I know
answer,
that
but
you're just asking
we don't want-
for an idea
Yeah.
of what is it really gonna take? When will you be
we-
happy
that-
with
we're going to
this?
follow that up.
But
We-
at the
we
same
will.
time,
Let
we're
me
not
say.
here to just make people happy, right? I just wanna make that clear.
We're
This,
out here to make people happy.
we're
down
not,
here to-
Come on up.
we are not going out of compliance on things. We're not trying to do anything outside of the law on purpose. We truly are doing what we saw in the book, okay?
I understand.
So,
I understand.
if
Chris?
we're still in compliance, we're not just here to make somebody happy.
Chris, Courtney, you two, you got young kids, right?
Yeah.
2 young kids, that's
that
what you're
have
talking
to
about, okay. Now, they've got a pond right next door to you that's open in the field.
Yeah.
To me, I would want a fence around
Here's the
that
thing, we don't
pond
care about
to
the
keep my
fence.
kids.
We honestly don't care about the fence. We never would have brought the fact that the fence is on our property up until they sued us for a water runoff situation. We were gonna let it go because as a neighbor, it's just like, whatever, they're over
Well,
a
it
little bit,
protects
it's
you,
fine,
though.
okay?
Who has a track record for suing people?
It doesn't matter if it protects me. I've said the exact same thing that you
Yeah,
said. I don't
yeah.
mind the fence being there.
I
The
would
kids,
want
the
it
dog
up.
can't go
I-
over there, it's
I
fine.
lost a friend that,
I could care less about their fence. The only point in me bringing up the fence is that we're being big sticklers about compliance when there's something out of compliance and it's not our deck. That was my only point in bringing it up. I don't care. It's on the township now and the court, like you said, to do whatever you guys have to do. We don't care about the fence.
Okay.
The only thing about the fence is that
Okay, do we
it's
wanna
out of
bring this up?
compliance.
And on the property.
Whether you guys enforce it or the court enforces it, that's on you. We don't care.
Okay.
That's the only reason I brought the fence up.
Very good. Okay. Thank you.
Give you a minute to look at this.
I've read this already, so
Okay.
I'm kind of familiar with it. If you want to address it in some way.
This has to do with the water issue that we won. Basically, we had an engineering expert come out and look at the property.
Right. I was going to ask you about this and ask Chris who he had, who did the work, the irrigation work on. Did you go ahead and do that?
I did.
Go.
I did all the work on the property.
And were you, did you have a consultant on there, or were you the consultant and
As far as
certifying the effectiveness of the drainage?
I had
that-
an engineer who was working on it.
Okay, that's just what I wanted to know. Okay, Ms. Schulteis, go ahead, Susan.
This, when you talk about affecting property value, you'll see in here, the third page of this, it shows what the original lots look like when we went to sell the properties.
That's it. Where are we bringing up now?
Hopefully, we're getting ready to conclude. I think this is just one,
It sounds like we're going deeper in the rabbit hole.
just,
about
just,
something that-
Oh, I'm sorry, I
I'm
don't have
thinking,
to, I don't have to cover that.
I'm thinking did you want to talk something about the property
No,
value?
It tells
or-
you in here, you see it.
Okay,
You
but
see
what my concern was that the work was complete, it was your concern, you filed the suit.
Mm-hmm.
The work, you won the judgment, the work was completed, and all parties were satisfied.
No,
Okay,
no, we just dropped it because we're just tired of fighting about some stuff.
Okay.
Lawyers are making, lawyers are
Okay,
making
hold
too,
on. Hold on.
we got tired of paying lawyers that weren't honest with us, so it's like, whatever.
Okay. So, we're not here to make anybody happy, but we want to find find a solution. So what is our solution?
Enforce zoning. The only reason I'm here is to enforce zoning. Now,
Okay,
if a decision's made that we're gonna allow. Excuse me, I'm sorry, I hear an echo in the back. If the
hold on, Chris. Go ahead, Susan.
if a decision is made that this is gonna stand,
Yeah.
it's not gonna help my property value and it
But
may.
we're gonna take that,
Okay.
on as our action to resolve that.
Okay, then when we come back and see what the resolution is, I'll go with that, but I don't.
Right.
I don't, you got anything to say? I gotta see to believe, because I've been coming here
Okay.
since 2000, well,
Mi- hold-
this,
Let me hold you, Mr. Gaines, would it be okay if we examine those measurements on the deck
Again?
again?
Again.
One more time.
From 6 days ago. Again.
Dale, do we have any pictures that we can offer as Exhibit A?
Not to that, not to that.
Dale didn't get any
Overhang.
pictures for the overhang.
She got plenty. She got measurements.
I hope she doesn't have any with the tape measure hung up there, but I think that's what we're looking for. That's what she's saying. She says, I want to know the overhang is 3 feet, which is in compliance with
well,
zoning.
2.5, actually, if you
Yeah.
go by the one section here. But you're still referencing a section,
It could be 2.5 by the time we get out of here. So we're gonna figure out what it is, okay? And we're gonna, okay, you wanna talk about the steps now?
sure.
Okay.
Then we can formulate, yeah, sure.
Okay, are the steps attached to the ground? Okay, they're on pavers? They can be moved. And Dale, would you cite the scripture, chapter and verse, where we talk about movable objects intruding into a
Oh,
setback?
that was my 19C piece, wasn't it? Yeah,
You have it, I got it right here.
yeah, just a minute. As I started putting all my stuff away.
But I think
Okay,
go ahead.
this is 19.8, okay? 19.811/C. It was the period, it was the thing that I handed to you. Susan, you should have a copy of this.
I wanted
And
to,
everything I'm going to read is in the brown pieces, all right? All right. 19.8 is projections into required yards. 19.81, certain architectural features may project into required yards or courts as allowed. 19.811, into any required front yard or required side yard adjoining a side street lot. Now, this is not necessarily the case, but it is the open case. A, cornices, canopies, eaves, or other architectural features may project a distance not exceeding 2 feet, 6 inches.
well, then this
That's-
doesn't apply.
Wait a minute. I'm not finished.
Okay.
Okay?
Taking it verbally.
B, fire escapes may project a distance not exceeding 4 feet, 6 inches. C, an uncovered stair and necessary landing may project a distance not to exceed 6 feet, provided such stair and landing shall not extend above the entrance floor of the building except for a railing not exceeding 3 feet in height. D, bay windows, balconies, et cetera, 19.812, subject to the limitation in subject 19.811, the above named feature may project into any required side yard adjoining an interior side lot line a distance not to exceed 1/5 of the required least width of such side yard, but not exceeding 3 feet in any case. Subject to the limitations, and this is 19.813, subject to the limitations in subsection 19.811, the features named therein may project into any required rear yards or to any required outer court the same distance as they are permitted to project into a front yard. This is basically has not been revised since 2015, if you look at the footnote at the bottom of the page.
Okay, the dimensions you just gave under 19.811, any of the required front yard and required side yard adjoining a side street lot line. We are not talking about a side street lot line. This is where twisting this code to meet your needs is happening, and this is not right. As written, let me read it again. Into any required front yard or required side yard adjoining a side street lot line. There is no side street here. There are no fire escapes. There are no uncovered staircases for a side street lot line. There is no canopies on a side street lot line because this is not a side street. This is where I'm saying this zoning is not being applied. It's being twisted to meet the needs of a whim that somebody has decided to make a variance or a difference, and they know it's not a variance situation. It then becomes, how can I take this code and move it around to fit my needs? That's what I'm talking about. That happened years ago to us over the same. I appreciate and I love the idea that you guys gave us an opportunity to talk about this, because in 2005, I went to the zoning department and I said, please enforce this zoning law on a business. And Ed Teets, being new to the job, 2 months, went out and said, okay, in order to do this, I need to get proof of a business, proof of documentation, and proof that they've been operating. So he came back and wrote me a letter about a month later and said, we approve it. This is grandfathered in, and it's like, we have lived on this property for 60 years. There is no business. We were there when the property changed, but our neighbor provided Ed Teets with false documents, and Ed Teets did not give us the opportunity to come back and say, hey, what do you have? Because what we had was certified aerial photos that showed there was no building and there was no business. We had to go and file a reversal for that zoning administrative. We proved, oh honey, it really is. I absolutely agree with you. And to show that it was lied and Ed Teets was misled, Mr. Conrad had provided false documents. This goes back. This is not just, we're going to make up something and make up. This goes back. I'll let you read it. I'll let you read it. Because this is not just, we're missing coding. This is get even with her. I'm sorry.
Okay, so are zoning guidelines inadequate to deal in an agricultural arena that has side yards that attach to other agricultural property adjacent to it?
No, that would be in 7.
That would be what?
In Article 7,
Do you
Article
have,
7 is
Chapter 7, which is the agricultural article,
is there a, can you get,
agriculture zoning.
can you give us that
It's-
information?
It's not, there's nothing in 7 that is like this. This is
Okay, nothing says anything about
exactly.
extensions of stairways.
No,
into-
because the exceptions and modifications are put in Chapter 19.
Okay, so if we have a situation where we have, hold on just a second, Chris. If we have a situation where we don't have zoning guidelines to direct us, which in this case we do not,
You do. On the setbacks, Ed Teets said it was 25.
but this is for what did they call it? A projection into a required. This would be a projection. This would be a different category as opposed to.
He doesn't have room for it. He does not, according to your book, according to what.
The book says.
We don't
no.
have guide. I don't see guidance. I mean, I don't.
There
This
lies the
definitions?
problem.
There is none.
There is none. Cut it off at 25 feet. There is no guidelines.
Well, what are you gonna do?
Right, so we would have to, this could, the only solution I would see for a projection into a side yard that is going from agriculture to agricultural or residential to residential, take out that side road twist in there is go back to the zoning commission board and say, we want a new guideline on what to enforce. Because right now, we have nothing to enforce. And it's not.
You have nothing to enforce, you've got steps in the setback. And
Yeah,
you have
But
no
that,
law.
but
No,
steps,
you have no-
but, well, that's an area we'll have to
You guys
to look
You
at.
can change it if you want, but right now, that's the way the law reads.
But I'm saying, but if I'm seeing a condition here that addresses projections. Stairs are projections. They're not attached to the ground. I can see where this is not
But
black
it's
and
not
white.
addressed here. It's not addressed in the
Right,
current
right.
zoning
How
law.
long, zoning's been since 1988, and you've never had this?
We have never had a family come and say, this projection steps are encroaching into I've only been here since 2017 on the board. Dale or Tom might have had a little more experience. Daryl might have had more. But to my knowledge, and we got a lot of zoning guys here.
Battery.
Well, why is it up to me? Why doesn't the owner have to take responsibility for this, for not checking this out first? If
He did. He got it approved at 25 feet setback. He did.
Okay,
But he changed his mind. So we're just gonna change the zoning.
Mr. Brandeis, did you want to introduce
Kevin
yourself?
Brandis, Traden Road. I am the vice chair on the zoning commission. You said this property is zoned agricultural? Setbacks don't apply in agriculture.
It does on residential, and Chris is a
Well,
residential.
which is it? Is it residential or is it
I'm not
agricultural?
building. He is.
I know, but
It's zoned.
he's still zoned agriculture.
He's a residential and he falls
No,
under
he
zoning.
still is in
May I
agriculture. So that steps doesn't apply. Dale?
Get charged up there, Dale. Come on, man. Plug yourself in.
Right. I want to explain something to most everybody, really, if I can. When you say agriculture and the uses thereof, and we have a chapter 7, which deals entirely with agriculture, property that is zoned agricultural. And in that are two permitted uses. Two permitted uses. One of them is agriculture. And if you're zoned agriculture, you can do agriculture on that property. The second one is called residential,
Thank you.
and it is permitted on an agricultural zone. Nothing else. The setbacks apply only to the residential. That's where she's correct.
Thank you.
It's
7.34.
still A1. It's still agricultural 1. All of you, most of you are sitting on A1
There's the
property.
50-foot back, and here's the
A1.
25-foot setbacks, that's agricultural.
The only place, we don't
That's
even
what you're
have
talking
any R-zone 1 people,
But she's
okay? It's a big, big difference. And that's what's got to be understood here
Thank you.
and everything else, all right? So we're having a little
Clarification.
clarification
Not a problem.
of what agriculture and residential are. Because the only place we have residential is Shandon and Okeana. And those are R2, not R1. All right? Permitted uses, that's what you look at.
My
That's my
point
case.
is we're trying to apply and fit something that does not fit in this issue. We were told initially it would be cut off at 25 feet. I don't know why that can't happen. Don't know why, it does not. And Ed T said, absolutely no exception, 25 feet, except in exceptions. And again, that is a parcel lot of, what is it called here? Exceptions and modifications.
Right.
And that's what he said. So that's the area you're citing, and that does not apply. Now, I understand you've never dealt with this before, and that you said, I do thank you for giving us the opportunity to have our say, because we didn't get that before with that earlier one, and it was very time consuming. It's a beautiful home. Chris is a hard worker. I mean, I've seen him work late nights. I mean, and as far as what he accuses, he has no proof of that. That's just spewing with anger, I think. I don't know. But I would believe that that house would be more attractive if you would have the steps either coming off the front or the back and a straight 25-foot to allow you that setback. Because that's what the zoning says, and that's what we were told was gonna happen. Does not address canopies and overhangs, and Ed Teets said the only overhang we allow is maybe a couple feet on the roof. I'm good with that. I am good with that. But 25 feet is 25 feet, not 23 and a half, not 22. And if you want to do canopies and address it in here, I'm good with that too. Make the changes. So that people know exactly, they got to know what they're building to. And Chris did. I was told Chris did. Now, his deck is beautiful and his house is beautiful, but he can get as much out of it going out to the back. He's got plenty of room coming out the back.
Okay.
Doesn't
I
have to
think
go to the
we've,
setbacks.
I think we've identified some areas in our zoning that we can
Modify.
tighten
Update.
up,
Update.
tighten up.
Is there anything stronger than water?
But the thing of it is,
And-
in modifying it, it grandfathers everything else in.
So
You can't grandfather something that wasn't legal to begin with.
I will be
I
talking.
agree to that.
I will be talking with Dale first thing tomorrow morning at 6 a.m. and we
Oh, no,
we
I'm gonna
will,
be here at 8, please.
we're gonna go through and get a way forward to address the issues that we've heard tonight. And-
All we've ever
and
said
we
is just
will-
enforce zoning fairly and across the board, the same for everybody, and this picking and choosing who gets to do what, that's not right. That, you gotta go with what's right, and I
We-
know you guys want that.
And we will-
Absolutely want that.
Well, our next scheduled trustee meeting is this coming Monday, but that will be a little too quick to get full conclusion on these issues. These issues can go until the next zoning commission board meets and get all
In
their heads
September.
together, because that will be
Yeah.
that'll be a
And
tall
we meet.
hill to climb.
We meet September 7th, is it?
Okay,
6th?
okay.
I do
Wednesday
thank
night.
you for providing
I-
this opportunity. I
and I-
truly do appreciate it.
And I appreciate, this was not easy, and I know Mr. and Mrs. Gaines appreciate being in the forum, and appreciate you guys being here in the forum. And with that, I will entertain a motion to conclude.
I'll make a motion to adjourn.
Mr. Brooker?
Yes.
Mr. Huff? Mr. Cole?
Yes.
We're adjourned.
We are adjourned.
8:46.
They'll let you know.